The Committee on Military, Veterans, and Homeland Security will come to order. Mr. Clerk, will you please call the roll to establish a quorum?
Chair Conlon.
Present.
Representatives Carter.
Present.
Shannon.
Present.
Rogers.
Here.
Morgan.
Present.
Magella.
Here.
Markinen.
Here.
Mazat.
Present.
Martin.
Here.
St. Germain.
Here.
Madam Chair, you have 10 members present in the quorum.
Representative Carter moves to adopt the minutes from the March 5th, 2024 meeting. Seeing no objections, the minutes are approved. Thank you. Today we will start by voting out Rep. Snyder's HB 5433, for which there is a committee substitute being offered by Rep. Shannon. The H1 substitute will clarify the language to ensure only members of the Michigan National Guard are eligible. It will also allow the department to establish any additional eligibility requirements that it deems necessary. Rep. Shannon moves to adopt the H1 to HB 5433. Mr. Clerk, will you please call the roll?
Chair Conlon.
Yes.
Representatives Carter.
Yes.
Shannon.
Yes.
Rogers.
Yes.
Morgan.
Yes.
Magella.
Yes.
Markinen.
Yes.
Mazat. Martin.
Yes.
St. Germain.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 0 passed, the substitute is adopted.
The substitute is adopted. Rep. Wagella moves to report HB 5433 with recommendation as substitute H1. Mr. Clerk, will you please call the roll?
Chair Conlon.
Yes.
Representatives Carter.
Yes.
Shannon.
Yes.
Rogers.
Yes.
Morgan.
Yes.
Magella.
Yes.
Markinen.
Pass.
Mazat. Martin.
Pass.
St. Germain.
Yes.
Madam Chair, you have 6 yeas, 0 nays, 3 passed, motion passed.
HB 5433 is reported with recommendation as substitute H1. Next, we will be hearing testimony on Senator Kleinfeld's SB 690. Senator, is the senator here? No. We have testimony, though, from somebody. Sorry. We've got someone from DMVA. Thank you for joining us today, and the floor is yours.
Good afternoon, Madam Chair, members of the committee. My name is Lieutenant Colonel Jason Evans, and I serve as the military judge for the Michigan National Guard. I am testifying in support of Senate Bill 690 because it would make important and necessary changes to the Michigan Code of Military Justice. Before addressing some of those changes, I want to briefly discuss the current Michigan Code of Military Justice, or MCMJ, and why it matters to the Michigan National Guard. As the preamble to the Manual for Courts Martial states, the purpose of military law is to promote justice, to assist in maintaining good order and discipline in the armed forces, to promote efficiency and effectiveness in the military establishment, and thereby to strengthen the national security of the United States. Like the Uniform Code of Military Justice for the active component, the Michigan Code of Military Justice is an important tool for commanders to enforce good order and discipline in the Michigan National Guard. The current Michigan Code of Military Justice was passed in 1980 and provides the jurisdiction, powers, and procedures for courts martial in Michigan. The enumerated offenses in the current code are primarily limited to military offenses. Some examples are AWOL, disrespect toward a superior commissioned officer, use of contemptuous words against state and federal officials, and failure to obey a lawful order. When I refer to these as military offenses, I mean there are no civilian equivalent crimes. These would not be prosecuted by civilian prosecutors. The MCMJ was intended to substantially mirror the Federal Uniform Code of Military Justice, or UCMJ. Federal law requires this consistency. According to 32 U.S.C. 326, each state's National Guard have general, special, and summary courts martial constituted like similar courts of the Army and of the Air Force. They have the jurisdiction and the powers except as to punishments and shall follow the forms, procedures provided by those courts. The MCMJ was last revised in 2005. It has not kept up with the numerous important changes to the UCMJ. The proposed changes to the MCMJ included in this bill in addition to better aligning the MCMJ with the UCMJ, will provide for a fair, more effective, and efficient system of military justice in Michigan. These changes will help the Michigan National Guard better address issues that undercut the organization's ability to fulfill its mission to the state and the United States. Here are some of the most significant changes SB 690 would make to the MCMJ. The bill would add additional offenses addressing, among other things, sexual assault, sexual harassment, misuse of government computers, retaliation, and recruiters engaging in prohibited sexual activity with recruits. While much of this conduct would likely be prosecuted by civilian prosecutors, making a court-martial unnecessary, including this type of conduct in the MCMJ provides military leadership with the tools to address these issues if civilian prosecutors are unwilling or unable to prosecute. Explicit inclusion of some of this conduct in the code also signals to members of the Michigan National Guard that leadership is prioritizing addressing these matters. The bill would also add a new section providing for victims' rights. This would ensure that victims of offenses under the MCMJ receive similar rights afforded victims of other crimes in Michigan. The UCMJ added a victims' rights article in 2019. This section is particularly important given the push in the military to provide greater protection to survivors of sexual assault. The section that authorizes non-judicial punishment for minor offenses would be modified to eliminate the right to demand a trial by court-martial if arrest and quarters or restrictions are not considered as punishments. This would give commanders the flexibility to impose minor punishments for minor offenses without the risk of an expensive and resource-intensive court-martial. Demanding a trial by court-martial also creates serious risks for the member. Non-judicial punishment is not a criminal conviction, but a court-martial conviction is a criminal conviction. Other states have made similar changes. Like the UCMJ, a new section would also be added to provide additional investigative tools, like allowing a military judge to authorize search warrants. The number of members or jurors for general courts-martial and special courts-martial would also be increased, consistent with the current UCMJ. The number of members required for a conviction would also increase, like the UCMJ, from 2/3 to 3/4. The punishments that can be adjudged by a general courts-martial, special courts-martial, and summary courts-martial would also be increased. For example, the maximum potential confinement for a general court-martial conviction is currently 200 days. That would increase to 2 years. The available fine would increase from $200 to $2,500. And this is more appropriate for the potentially serious conduct at issue. Section 36 would also be revised to clarify that the military rules of evidence and the rules for courts-martial, as promulgated in the most recent version of the Manual for Courts-Martial, apply to courts-martial convened under the MCMJ. This is consistent with the federal requirement that our courts-martial are supposed to mirror those in the active component. Lastly, the statute of limitations would be increased from 2 years to 5 years. This change is important because victims of crimes may delay reporting potential violations of the MCMJ. I appreciate the opportunity to provide my input on this important bill, and I'm happy to answer any questions. Thank you.
Thank you for your testimony. So we are updating for the first time since 2005, you said, right? How often is it updated federally?
Yearly.
Yearly. Right.
There aren't significant changes made yearly. The most recent significant changes were made in 2019, but it is updated yearly as part of the NDAA.
Right. So in the future, we might need to update again, is what you're saying, too?
Yeah, in some other states, for example, Arkansas. I was just in Arkansas a few weeks ago for a military judges course, and the military judge in Arkansas indicated, and I saw this actually when I was trying to build this code, that they update every 2 years on average.
And why didn't we update since 2005?
I'm not sure why we haven't updated. I think we probably should. I think that would be a good idea to have folks within the legislature who, are kind of available to to help update this as updates are required.
Just out of curiosity, what is sort of the breakdown of the types of court martials that have been ordered over the last few years in Michigan?
Well, it's interesting, like most state National Guard, we typically don't handle courts martial. Now, there are a few that are working their way up to me right now. That's my understanding. I don't see these until they're actually referred. So I think that it's likely in the future you'll see more of these. What the code is typically used for presently are Section 15s, which on the active component are called Article 15s. So these are non-judicial punishments. These are the punishments that would typically be used to cover a lot of those military offenses. And then, the reality is, if you're dealing with a member of the Guard who engages in some sort of significant criminal activity, they're typically going to be prosecuted by civilian prosecutors. And then what we do, and really what a lot of my job is as the military judge, we do administrative separation boards and just kick the member out. But there are circumstances in which it's important for us to be able to prosecute. I think it's likely we're going to see that more in the future, and there are states that handle significant numbers of courts martial, actually.
Thank you. Representative Martin?
Thank you, Madam Chair. Good to see you, Colonel. I'd be remiss, as the most recent Command Sergeant Major for the Defense Force, not to ask a couple questions. Do you know if the Michigan Courts Martial ever identified the volunteer services in the Court Martial Manual?
In the current MCMJ, if you're a member of the Defense Forces, you would fall under the MCMJ, just like a member of the National Guard.
That's what I was hoping to hear, because we're still trying to spell it out, and I was wondering, but I would assume that a lot of that would go to a civilian court, probably be a recommendation.
Yeah. I mean, unless you're dealing with like military offenses, right? Or sometimes you might end up with a jurisdiction issue. And what I say by jurisdiction issue is, and this is really where other states have run across or have had to deal with courts martial. Let's say you have a Michigan unit, you send them to Texas to do training. Something happens during that training. Maybe all the facts don't come out until they come back, or maybe they do come out. And the decision is, especially if they're on an active duty base, send those guys back to Michigan, right? We don't want to deal with those guys. Michigan will take care of it. Well, you send them back to Michigan, and every civilian prosecutor in Michigan, including the Attorney General, would say, I don't have jurisdiction. This happened in Texas. The folks in Texas are like, you're not bringing them back here. Like, we don't want your person back here. We're not going to extradite them back to Texas. Then it's left on us, right? We're sort of the last line of defense in a case like that. And that happens somewhat routinely, right? I mean, we send folks to training all over the country all the time, or to missions all over the country all the time. And I think there's a misperception in most places, especially amongst civilian prosecutors, that like, these are Michigan folks in the Michigan National Guard, let Michigan deal with it. And they come back and we say, well.
Yeah, I can see a scenario where the VDF may get training out of state.
Yes.
Not necessarily deployed, because it's not in the scope of the mission per se, but I'm as a civilian manager, when I first retired from the Air Force, the thing I missed the most was that UCMJ failure to go, things like that.
Yeah.
And so I just want to make sure that if we reconstitute and get the SOPs out for the VDF, that it's clear that we're in the courts martial and we can use those, Article 15 type actions.
Yes,
Thank you.
and that is clear in the code, that whether you're in the VDF or you're in the National Guard, that you fall within the jurisdiction.
Thank you, sir.
Yep.
Thank you.
Representative Morgan?
Thank you, Chair. Just two quick questions, if I may. I'm curious about the change removing the ability of the governor to appoint the state staff judge advocate. I'm just curious why that change would be included.
Really, the reason why that change was included was to match up with reality. As far as I know, I mean, I've been in now for 17 years. I've obviously been known other judge advocates who have been in for a lot longer than that. And as far as I can tell from kind of an informal history, that position's never been appointed. And as a result of that position never being appointed, in fact, we've got, like I said, we've got a few courts martial that are working their way up now. There are specific duties that position holds, that there isn't anybody in that position to carry out. So in fact, I made a request that we ask the governor to appoint a person in that position. But really, it really has to do with the realities of the fact that position hasn't previously been appointed. It really does make sense that the tag as the head of the National Guard would be the person to appoint his chief lawyer. So I mean, I think it makes sense from that standpoint. More importantly, it's just the reality. It hasn't been appointed in the past.
Okay, and then another question is the list of added sections in SB 690. So adding sections dealing with the punishments for various crimes. There's a lengthy list being added, and I'm just curious, are those just matching what the federal changes are over the last 20 plus years, or where do those additional items come from?
Well, I mean, we still have a number of, they call them punitive sections or punitive articles in the UCMJ that we don't include, like we don't have murder, for example, and there's some practical reasons why we don't do that. But really, those come from, one, the types of offenses that we sometimes see in the National Guard and end up having to sort of deal with in the National Guard that might fall outside of the civilian system, and two, in sort of deciding what should be included and not included. A lot of this came down to looking at other states and what other states have included and what sort of makes sense in terms of what they've dealt with and what they've seen, and that's why those are added.
Okay, so does that not mirror whatever the federal?
No, that would not mirror, that doesn't mirror all of the punitive articles within the UCMJ. Yeah, and the federal statute that requires that our act, I mean, this is a simplistic way to say it, that our act mirrors what's in the UCMJ, really deals to goes to the procedures and forms, right? So it's most important that we follow similar rules of evidence. It's most important that we follow similar rules of court. But the punitive sections, we don't believe, and other states don't believe, that same statute requires that we exactly mirror that. And really, like I said, then we'd be including things like murder in our code, and that would put us in a totally different situation, especially in terms of punishments, right? Because you can't include murder and then also have your cap being 2 years. It's almost right. So, I mean, we already have some fairly serious offenses that we're going to be somewhat limited on in terms of punishments. But hopefully, if we see those really serious offenses, we're getting the civilians involved, and they'll prosecute.
Thank you.
Representative Rogers.
Thank you. I have a couple of questions as well. I've spent quite a bit of time looking at civilian life, and we've had quite a few public, very high-profile cases in the wake of Larry Nassar. There's been other cases with sexual assault. So I'd just be curious if you could follow up with information, you may not have it at your fingertips, about the illegal sexual activity and sexual assault sections and what that specifically looks like, and if you are mirroring other states, if we could be provided a list of what other specific states, that would be fantastic. And then my other question is, you started mentioning, it depends on jurisdiction. So which law is followed, or which version of rules is followed if our National Guard members are deployed to, say, Washington, D.C. or another state? How is the jurisdiction, and which set of rules are they to follow?
Yeah, so there's, and I've got a note on the sexual assault piece, and I'll follow up on that. So really, there's two statuses that you would fall under in the National Guard. Typically, you're in what's called Title 32, and really it just has to do with the pot of federal funds that fund you. If you're in Title 32, your commander-in-chief is the governor. That's your typical National Guard duty. A lot of times when we send folks, like for example, when we sent folks to Washington, they were still Title 32, right? So they fell under the Michigan National Guard. The jurisdiction would be the Michigan National Guard. When I deployed to Afghanistan, when we send folks on deployments overseas, they're in Title 10 status, so they're in the same status as the active Army. In fact, you become part of the National Guard of the United States, and then you get, subsumed into the active component. And in those cases, if you committed a crime, then you're prosecuted under the UCMJ like any other member of the active military. But in terms of jurisdiction, so if we're in Washington, you're under Title 32, you fall under the jurisdiction of our act, you would also fall under the jurisdiction of the local civilian authorities if they want to prosecute you.
That seems complicated. Thank you.
Yeah, thank you.
Thank you so much for your testimony today.
Thank you. I appreciate it.
In support of the bill, not wishing to speak, Heather Firestein with the Department of Military and Veterans Affairs. And seeing no further business before the committee and without objection, the committee is adjourned.